Good evening and welcome to our webinar on protected conversations. I'm Amy Stroud and this is Sam Healy. This is the last session in the series of employment webinars. Sessions 5, 6 and 7 run from next month to July, and those will be released later this week. Any questions you've got, please put them in the Q&A box and we will address them at the end if we have time permitting. Also an email which will contain this recording, the slides and a feedback form for you will be circulated over the next few days. So this webinar focuses on the settlement of employment disputes before the matter even comes to an employment tribunal, perhaps even before legal representatives are instructed to act. A settlement in-house between the employer and the employee, where they can discuss the matters between themselves and hopefully reach an agreement, perhaps on the employee's departure from the business. There will be particular focus on Section 111A of the Employment Rights Act. This is designed for anyone who's in this situation, but with particular focus, I think, particularly useful for employment lawyers and HR professionals. The format for the webinar is we will look firstly as a preliminary on the general without prejudice rule as a framework, if you like, and then go on to look more particularly at Section 111A and how that assists in both employers and employees. And then moving on from that, recent case law concerning that subsection, in particular Gallagher and McKinnon auto tyres, and finishing up with practical tips on how to capitalise on the benefits that Section 111A brings. In terms of looking at settlement of disputes before they reach the door of the EAT, and we're obviously rather limited in when we look at statistics or try to understand how many disputes can be settled beforehand, because we simply don't have the data. The best we have, all we have to go on really, is the government website data and ACAS data. And ACAS collect data on the effect of early conciliation, and we can see from this that early conciliation is actually extremely effective at keeping disputes out of the tribunal system. The most recent figures published by ACAS show that between October 2023 and March 2024, some 68% of early conciliation cases didn't progress to the tribunal. So in other words, no ET1 was completed. In the subsequent period, so April to September 2024, some 69% didn't progress. So there's a good chance, better than 2/3, that early conciliation will avoid the need for employment tribunal proceedings and will resolve the dispute. But even if early conciliation doesn't work and an ET1 is issued, there's still a very good chance that the matter doesn't proceed to a final hearing. Just under 80%, in fact, of cases are resolved before a final hearing is reached. And as I said, if you want to look at the statistics in more detail, well, we've got the link up there. But to go back to the focus of the webinar and looking at things earlier in the process, hopefully before you get to an ET, before you even consider ACAS, what is the scope for employers and employees to mutually agree a departure from the business and avoid, before there's entrenchment by either side and when it's still possible to settle. And this is really where protected conversations or pre-termination negotiations come into play. And they've obviously been with us for over 10 years. They were introduced by the coalition government in July 2013. What happens in a protected conversation? You have an ideal situation where the employee an employer calls the employee to a meeting and suggests an off-the-record chat, and that is a resolution where there's an agreement in place, an agreed departure date, perhaps a lump sum payment, or some sort of agreement that the employee maybe doesn't need to work their notice. And there's a simple settlement agreement which finalises this. And the employer has the comfort of knowing that the matters that are raised can't be brought back, can't be used against it in subsequent proceedings. That's what most employers would like to happen, but of course things aren't always so straightforward. The employee may not want to leave. The employee may not like what he or she is hearing, and in the event of a subsequent management process or redundancy exercise, the employer may find that the matters that were discussed in that conversation in the off-the-record chat are actually raised in a subsequent internal process or even in possible tribunal proceedings. There's also the fear that the employee might choose to resign and claim unfair constructive dismissal, relying upon things said at that meeting. So it's really ideal to have a situation where employers can work out how they can they're best equipped at having protected conversations with their staff with the least risk possible, resolving disputes in-house to the extent that they can, finding a quick and cost-effective way to deal with a member of staff who might be underperforming or perhaps simply isn't happy in the business. Before we look then at section 111A in more detail, it's important, I think, to look at the main without prejudice principle as the backdrop, if you like, because of course this is a rule that applies not just in employment tribunal proceedings but also in court proceedings, a general rule which of course prevents any statements made during a without prejudice conversation being used in subsequent tribunal or court proceedings. But that protection is only available, as you know, where there's an existing dispute between the parties. So you can't rely upon the protection of that if there is no dispute, or there's at least no contemplation or prospect of a dispute arising. The protection just simply isn't there. And the rule is quite strictly marshalled, though it's not always as straightforward as one might think, and the dividing line can be heavily fact dependent as to whether the without prejudice principle operates or not. There are exceptions, of course. You may know about the unambiguous impropriety exception, where tribunals and courts have concluded that, in fact, the parties can't take advantage of that without prejudice rule, even where there perhaps was an actual pre-existing dispute. There are 3 cases you'll see listed in the slide, which I'm just going to examine briefly before we turn to section 111A, as highlighting perhaps some of the problems that employers and employees might encounter if they are seeking to rely upon the general without prejudice rule. Mezzo Terro and BNP Paribas, quite an established case where the claimant returned from maternity leave and raised a grievance about her treatment by her employer. Specifically about not having her old job back. And she was invited to a meeting, and at the meeting, not before, she was told that the discussion was without prejudice. She was also told there wasn't any position for her at the bank, and she was offered a redundancy package. She claimed discrimination and victimisation in the tribunal, and the employer, lo and behold, said, well, you can't refer to the meeting at all because it's without prejudice. Now, the tribunal and the EAT upheld the tribunal's conclusion that the meeting wasn't without prejudice. And central to that was its finding that there wasn't an actual dispute at the time of the meeting. Yes, the claimant had raised a grievance, but that's quite a well-recognised mechanism. A grievance doesn't necessarily mean there's a dispute, particularly as the grievance wasn't about any decision to terminate her employment, but rather about her complaint about not having her old job. And the respondent had committed to hearing her grievance. It was also material to that there was found to be an unequal relationship between the parties. The fact that the claimant had only been told of the status of the meeting, once it had started, made it unrealistic to view the without prejudice status of the meeting as agreed. And also the EAT held that it was an abuse of the without prejudice principle to use it to conceal evidence of a discriminatory dismissal. And mezzo terror is a classic case of the public principle that tribunals need to be able, the evidence of discrimination needs to be open and within the purview of the tribunal to enable it to make findings. As a counterweight to mezzo terror, it is worth having regard to Garrod and Riverstone management, the case of Garrod and Riverstone management, where you have similar facts. Ostensibly, you have a claimant returning from maternity leave, but that does have its differences, because in that case, the tribunal found there was an existing dispute at the date of the meeting. And the claim that the claimant subsequently brought, in which she tried to rely upon the contents of the meeting, in fact rested on events that preceded the meeting, rather than, unlike mezzo terror, the meeting itself forming an unlawful act and an integral part of the claim. Whereas Garrod, the meeting was really just part of the narrative. And I think what is also quite useful to bear in mind when you're looking at Garrod is that the EAT said in this case that it's important that the parties can approach negotiations free from any concern that they'll be used for evidence gathering. It is not for them to comb through correspondence to try and find equivocal words or actions that might support an inference of discrimination, to try and take advantage of the unambiguous impropriety exception. The third case, again, I flag for your attention, is Hudson and Oxford University. In this case, the claimant brought claims of whistleblowing and unfair dismissal. And as part of those facts, the registrar of the university had written to the claimant stating that the allegations he'd made against the director and assistant director of the respondent was so serious that there wasn't any prospect of him returning to his employment at the university to work for it in any capacity at all. And the tribunal said, and the EAT said, overturning the tribunal's decision that this letter was without prejudice and couldn't be referred to, that no, it wasn't, because stating that he couldn't return to work for the university in any capacity was by no means an attempt to genuinely settle a dispute, and so therefore it didn't come within the without prejudice principle. And also it did also fall within the category of unambiguous impropriety. So you can reach certain principles from those cases which are important to bear in mind when you're looking at potential advantages of section 111A. The employer can't use the without prejudice rule to try and accelerate matters, to discuss the ending of the employee's employment before it's even on the agenda for the employee. And it also can't be used as a sort of label or cloak for discussions if in fact what the employer is saying is not a genuine attempt to resolve the dispute. Where the employer, as in Hudson, is simply stating its position or its viewpoint, that is not going to amount to a genuine attempt to settle. So the words without prejudice, as we know, are not a magic, some sort of magic solution that which will bring about privilege protection. So, given that it has its limits, and that tribunals and courts are certainly alive to attempts to use it to try and cover up things that perhaps should be reported or relied upon, how does section 111A fit in to all of this? So you can see here the section as it's set out, that the fundamental idea is that employers and employees have the option of ending their relationship swiftly and amicably without the need for any formalities or any delay. Some sort of mutually acceptable arrangement can be reached that both can tolerate and both can agree to. And there's definitely an attraction to that, isn't there? The employer can act decisively and quickly without any, as I said, without any formal process. And even if it doesn't work out, the employer has that safety net, that assurance that what has been said at that meeting can't be disclosed in any subsequent unfair dismissal claim. It's about encouraging frank and realistic discussions. And even from the employee's perspective, there are advantages because they can get a resolution, particularly if they're unhappy, in what they're doing. They can get resolution and certainty in a situation where they might not otherwise have been able to do that. So in terms of looking at the section, you can take advantage of it in relation to an ordinary unfair dismissal claim that's subsequently brought to the employment tribunal, and there, in that case, the parties cannot rely upon what is said in those discussions, and the inadmissibility of them extends not just to the offer and the discussions held, it extends to the fact of the offer and the fact of those discussions, not just what's said, the content of them. And it would also include any relevant satellite discussions between managers or between an HR advisor, say, not just the direct discussions that the employer has with the employee. Now, there are various aspects of this that Sam is going to run through with you. For example, the question of improper behaviour, you can see it's subsection 4, and also what exactly is meant by pre-termination negotiations. I should just caveat before I turn over to Sam that in relation to it's important to bear in mind that this does not apply when the claimant alleges the dismissal is automatically unfair. In those situations, the evidence of negotiations will be admissible. And also, the without prejudice protection that is offered by this is savers to costs. So the employer and employee can reserve the right to refer to it subsequent to the discussions or the offer subsequently on an application for costs. And so the tribunal would go on to hear any substantive unfair dismissal claim and then decide the question with full disclosure of those discussions, decide that any application for costs. And that right's extended, of course, to both parties. So both the employee and employer can rely upon the content of any discussions on questions of costs. So, and finally as well, it's not possible, as I understand it, for the parties to agree to admit evidence either explicitly or implicitly. They can't waive, as long as the exceptions don't apply, and as long as this isn't, we're talking about an ordinary unfair dismissal claim subsequently, the privilege can't be waived by either party. So without more ado, I'm going to hand over to Sam, who will go through section 111A in more detail.
Thank you, Amy. Thank you very much. So obviously you've got there on the slide the actual wording of section 11A, which Amy's already touched upon. And I suppose the most important thing to get right at the outset is that the default rule is that pre-termination negotiations are inadmissible. So that's the sort of starting point, as it were. You'll see under subsection 1 that it talks about that rule of inadmissibility being relevant to any complaint under section 111. And just to remind ourselves, that makes the point that this only applies to a complaint of unfair dismissal. And I'll come on in a few moments to look at that sort of situation where you have, as is often the case, complaints of unfair dismissal alongside complaints of discrimination under the Equality Act or the other types of complaint before the tribunal. And And then the second subsection there, which I'm going to touch upon a little now, is the definition of pre-termination negotiations. Because right at the start there, we see that this principle of inadmissibility relates to that term of pre-termination negotiations. There's a definition which you've got in subsection 2, which perhaps speaks for itself. But if I just go on to the next slide, which is this one here, there's some principles to bear in mind when you're looking at what are and what aren't pre-termination negotiations. Now, the first thing to bear in mind is it doesn't need to involve, in order to fall within that definition, any specific monetary offer to the employee. Any discussions that relate to termination on agreed terms are capable of being caught by section 11A. But there does need to be some element of discussion or negotiation between the parties, however limited or perfunctory that might be. If you're an employer who presents the employee with no real option, i.e. We're going to dismiss you, but here's some alternative, then that is likely to probably be regarded as something where there's no real sort of discussion or negotiation, more of a presentation of a sort of a fait accompli, if you like. And there are some cases before the Employment Tribunal, one of which is called Crespigny and Information Security Forum. That's spelled CRESPIGNY, from 2014. You'll find it in the IDS handbook. That's an example of a situation where the employer, in that case it was the board, had refused to back their CEO on the dismissal of a member of staff. They called the CEO to a meeting, does the board of directors, and the CEO is asked if he wants to resign. He says no, and the board's chairman tells him that he had lost the confidence of the board and there would not be a job for him on Monday morning, but they wanted to end this employment in a, quote, constructive manner. Now you can see in that sort of situation that the employee hasn't got much of a choice, and there's no real negotiation or discussion as such. It's more a position where you've got the employer basically presenting the employee with something that's already done and dusted. And in that case, the tribunal said, well, there's no real negotiation there, so it wouldn't fall within pre-termination negotiations. And perhaps the second bullet point on that slide there, perhaps obvious one, is that the parties don't actually need to reach an agreement. So even if the employee declines any or all offers and says that right at the start of the meeting and shuts down the discussion, as it were, then the confidentiality enacted by section 11A would still be preserved. Now, the key thing, perhaps, the third bullet point, and which distinguishes it from the without prejudice rule, is that there's no need for an existing dispute between the employer and the employee. So this can be something, and this is really the advantage to the employer, this could be something which is entirely new and hasn't crystallized into a formal dispute or the sort of thing which would be covered by the without prejudice rule. The situation, the section in its protection is not limited to situations, of course, where it's the employer that's initiating the settlement discussions. So you could have situations, perhaps they're less common, where it's the employee who's leading the discussion. The ACAS guide on settlement agreements gives an example of an employee who maybe has a personality clash with another employee at work, which is affecting the team performance, and that employee may approach the employer to see about the possibility of leaving with a good reference and a payment. So there's no reason why, in principle, you can't have the employee making the initial approach, as it were. Now, just going back briefly to the previous slide and the other subsections, just so we understand the framework of how the section works. Amy's touched upon this. Subsection 3 is an important restraint, if you like, or restriction on the general principle of inadmissibility of the pre-termination negotiations. And that's because it doesn't apply the inadmissibility principle if we've got an automatically unfair dismissal. So someone who's alleging perhaps unfair dismissal owing to pregnancy or trade union related activities, in those cases, the exclusion wouldn't arise. And it's also important to bear in mind that there's a EAT case called Harrison and Aryman Limited, that's spelled ARYMAN, from 2019, which in which the EAT held that section 11A3, so that's that exclusion for automatically unfair dismissals, is triggered whenever the claimant puts their case on the basis of an automatically unfair dismissal. So if that's part of the claimant's complaint, as it were, then without getting into the merits of that, then it will be regarded as a situation where the inadmissibility principle would not apply. And the I suppose the clue to that is that it does say in subsection 3 that phrase, according to the complainant's case. In other words, if that's the way the complainant or claimant is putting it, then the exclusion doesn't apply. Now, the subsection 4 is probably the most important exclusion to the principle, which we're going to look at in a bit more detail with reference to the Gallagher case in a few moments. This is the exclusion which is that if the tribunal's opinion is that there has been something improper said or done, or there is a connection with improper behaviour, then the exclusion in subsection 1 only applies to the extent that the tribunal considers it just. So this preserves, this is the subsection which requires really the tribunal to form an opinion and effectively make a finding that something said or done by the employer has amounted to improper behaviour. And then if they do that, it's really a sort of two-stage test, and the tribunal would have to consider whether it's just and equitable for that thing said or done to affect the application of the inadmissibility principle. And say, we'll come on to that in just a moment. The last one, which Amy's already mentioned, is really just there to preserve the without prejudice save as to cost rule in the context of section 11A. So if I move on to this slide here, now the first bullet point there reiterates that the exclusion only applies to ordinary unfair dismissal complaints. If you have an employee who brings a range of complaints, it's quite possible that you'll have a situation where the pre-termination discussions are admissible for the discrimination aspect of the case, or indeed perhaps for a breach of contract aspect of the case, but it wouldn't be admissible for the unfair dismissal element. So it's important for an employer to bear in mind that if the employee rejects the settlement offer at the protected conversation stage, you could end up with a situation where the employee is allowed to rely on what was mentioned in that meeting in the context of a discrimination complaint, but not be allowed to rely on it for the purpose of the unfair dismissal complaint. And the authority on that is Faithorn, Farrell, Timms and Bailey. Now, just to deal with that case now, this was a situation where the claimant was a part-time office secretary within the respondent surveyor firm. The claimant started discussions about settlement after it had been made clear to her that part-time working was no longer an option. So it's one of those situations I mentioned earlier, where actually it's the claimant that's kind of taking the lead in terms of the settlement discussions. Solicitors got on board on both sides, and there was without prejudice correspondence followed. The claimant also lodged a grievance relying in part on what had happened during these settlement discussions. And the grievance, part of which was that the claimant's case was that she was being bullied out of her role as part of a strategy to avoid paying her compensation. That grievance was not upheld. The attempts to settle between employer and employee got nowhere, and the claimants then, perhaps predictably, started a claim for constructive unfair dismissal, but also, importantly, she complained of sex discrimination, relying on the correspondence that had passed between her side and the respondent's side. The claimant's case was that the respondent's approach to her in those communications was part of this course of conduct designed to force her out and resign. So right there, you see, you've got a situation where the tribunal is going to have to grapple with the question of whether the communications and the documentation which passed in between employer and employee in the context of settlement discussions was admissible or not. And the tribunal has a preliminary hearing to discover that, to resolve that question. The ET decided in the Fatorn Farrell Timms case that none of the documents were inadmissible, whether by virtue of section 11A or the common law without prejudice rule. Its reasoning was, well, that section, as we mentioned, only applies to unfair dismissal, whereas there were other complaints here, including sex discrimination. And they also ruled to the ET that there was nothing wrong with referring to the simple fact that there had been offers and discussions, and section 111A was designed to capture details of the offers. This boiled down to meaning that the employee could rely on the fact of the discussions when arguing that she had been constructively unfairly dismissed. Now, the EAT rules, well, it departs slightly from the tribunal because it says, well, just because there's a discrimination complaint before the ET as part of the case, that does not mean that there's some kind of blanket rule of inadmissibility in terms of the pre-settlement discussions. Instead, the ET should allow evidence to be admitted for one claim, for example, the discrimination aspect, but not for the unfair dismissal. And it also, I think Amy did touch upon this earlier, indicated to the EAT that what's rendered inadmissible by section 11A is not just the details of the offers, but the fact of discussions and the making of offers, which perhaps makes sense also. There's a small footnote also in the decision which covers the following principle in the EAT decision. And that's this, that the exclusion in section 111A renders inadmissible not just the discussions between the employer and the employee, but also discussions between managers, so people on the employer side, if you like, rather than just the sort of exchange of information between the two sides, employer and employee. So just finishing off on that slide, the other points we've mentioned, complaints of automatically unfair dismissal excluded, and only predetermination discussions are caught. So if a dispute about the date of if there's a dispute about the date of the EDT, then that's the effective date of termination, then obviously that will need resolving before the tribunal can decide whether section 11A applies or not. So what I want to move on to now is to look at the key exclusion in the section about improper behaviour. So what is improper behaviour under section 11A(4)? And as I indicated earlier, this is perhaps the most important exception. If there has been improper behaviour or something connected with that happening, then the tribunal can allow evidence about what was said or done in the pre-termination discussions to be admitted if it considers it just to do so. So it's first of all important to bear in mind that this term, improper behaviour, is wider than the concept of unambiguous impropriety, which is the principle which applies when you're looking to avoid the without prejudice rule. So we're looking at a wider concept. A broader approach will be taken, and there's more flexibility for the tribunal when applying the improper behaviour test than perhaps the court or the tribunal in applying the common law unambiguous impropriety test. Second point to bear in mind, again, it's on the slide there, is that this is a two-stage test here. Was there some improper behaviour in the course of the discussions, so in that meeting that took place between employer and employee? And if so, is it just that the confidentiality of the discussions should be preserved? It's important to note there that the finding that a party has acted improperly doesn't automatically mean that the settlement discussions are rendered admissible. Rather, the tribunal has a discretion to decide whether it's just for the improper behaviour to alter the principle of admissibility. So you've also got a link there to the ACAS Code on Settlement Agreements, which gives some examples, a non-exhaustive list of what could be considered improper behaviour. So some of them are obviously fairly obvious, such as harassment, bullying and intimidation, including through the use of offensive words or aggressive behaviour. So if the employer engaged in that in the meeting, that's clearly going to be something which is captured by this term. Unsurprisingly, physical assaults or the threats of physical assaults are also mentioned by ACAS, as are all forms of victimisation. Perhaps a more sort of grey area is that of putting pressure on a party. So ACAS suggests that, for example, not giving reasonable time for consideration of the proposed settlement agreement, that might amount to undue pressure, which could fall under the term or under the umbrella of improper behaviour. Likewise, the employer saying that before any form of disciplinary process has begun, that if this settlement proposal is rejected by you, then you will be dismissed. That kind of sort of gun to the head type approach by the employer will very likely result in a finding of improper behaviour. And then from the other side of the coin, if you like, ACAS give the example of an employee's improper behaviour, including an employee who threatens in the settlement discussion, to undermine the employer's public reputation if they don't accept the employee's terms. So there's some examples there about, as I say, non-exhaustive list about things which might be captured by this term of improper behaviour. But that really takes us to the sort of driver behind this talk, which is a very recent EAT decision on improper behaviour, and perhaps one which is surprising on the facts when you delve into them. It is useful, I think, for employers, particularly in a redundancy context. So in a case which doesn't involve questions of misconduct or the likelihood of there being any kind of misconduct investigation, but a situation where you're looking to dismiss an employee possibly on the grounds of redundancy, Gallagher gives the employer some comfort that Section 11A is perhaps a useful tool to avoid a protracted redundancy exercise. So just looking at the facts of the Gallagher case, Mr. Gallagher was employed by the respondent as a branch manager. He took a period of sick leave during June and July. This is in 2022. So just a 2-month period of sick leave. But whilst he's off sick, the respondent, as is often the way, covers his role. And they found that they did so without any apparent difficulties. This led the directors of the respondent company to begin to wonder if they could manage without a branch manager altogether. In other words, manage without Mr. Gallagher. So with that in mind, they invite him to a meeting on the 1st of August 22. Now, ostensibly, the purpose of the meeting was to discuss his return to work because of his 2 months absence. But as matters panned out, there was only a brief discussion about his health, and then things turned into another area. And that was that it was suggested to the employee, to Mr. Gallagher, by his bosses, that his employment perhaps should end by reason of redundancy, because they had managed to deal without his services during his absence, and that an offer was made of an enhanced redundancy payment of £10,000. He was also told that if he accepted it, the parties would sign a settlement agreement, and that's an important feature of the case, which we may need to come back to in just a moment. And so he says, look, if you take this, well, there will be a settlement agreement. If you reject it, he was told that the parties would proceed down a sort of formal redundancy procedure. Now, Mr. Gallagher was given an initial 48 hours to consider that proposal. There were further discussions, but as he hadn't accepted it within the 48 hours, the employer decided to invite him to a formal meeting a few days later to discuss his potential redundancy and the possibility of suitable alternative employment. Mr. Gallagher ends up being dismissed by the employer, and he brings the tribunal proceedings. And you can understand that his case was that effectively the redundancy exercise that did pan out was a bit of a foregone conclusion, he relying upon what had been said at the pre-termination discussions. It came on for a preliminary hearing before the tribunal to decide if the discussions fell within the ambit of section 111A and so were inadmissible. The tribunal found that they did fall within the ambit of section 111A and rejected Mr. Gallagher's argument that the impropriety exception in subsection 4 had applied. So the nub of the claimant's appeal to the EAT was, look, I had been placed under improper pressure to take an offer. I've been told I had 48 hours to consider the enhanced redundancy package, and it had been perverse to the tribunal to reject the argument that subsection 4 applied. The EAT agreed with the employment tribunal that the discussions were inadmissible and rejected his argument that there had been some improper behaviour. Now, in particular, they rejected the suggestion by the claimant that he'd been told he would be dismissed if he did not accept the settlement offer. The tribunal had found as a fact that Mr. Gallagher had been told by his managers and directors that the branch manager role could be covered by the directors. But the tribunal had been clear that this did not mean that the claimant was necessarily going to be dismissed. So a key fact really in this case is that there was that finding of fact by the tribunal that he wasn't told, was the claimant, that you're definitely going to be dismissed. What he was told was, we're looking at the possibility of your role being made redundant. And of course, the EAT says, well, just because an employee is told of a possible redundancy doesn't mean necessarily that he will be dismissed or they will be dismissed, because there could, of course, be alternative employment found. The EAT also noted that the ACAS code talked about undue pressure in the context of a disciplinary process. For example, a situation where you're told if you don't take this offer, then you will be dismissed for misconduct. Whereas what we had here was a redundancy process. That was an important distinction. An employer who has not yet started investigation into misconduct, who says that the employee will be dismissed, so the sort of gun to the head approach, and tells the employee, if you reject the settlement proposal, your job's over. Well, that effectively is confirming what the outcome of the investigation in the misconduct process will be. In such a situation, it's very likely that the employee will feel under pressure, and that's why subsection 4 should apply. And it's quite different in a redundancy process, where there's no need for an investigation into disciplinary matters. And just because the employer states that a role is redundant, as I've just mentioned, it's not the same as saying you will definitely be dismissed. So there's nothing per se wrong in suggesting that the claimant's role was redundant. Another aspect of the challenge by Mr. Gallagher and the EAT was that he had been brought to the meeting with the employer on false pretenses. You'll remember that when he walked through the door, metaphorically at the meeting, he understood that the purpose of the meeting was to discuss his return to work. So he was saying, look, I was effectively led up the garden path. I've been lied to. But importantly, the employment tribunal had not made a finding that there'd been any lies involved. They said that there probably had been some unfairness to the employee in the employer not being wholly transparent about what the meeting was to discuss. But then the tribunal noted that it wasn't considering whether this was unfair in the context of section 98(4), but a quite different test of whether there was impropriety capable of ousting the default position of inadmissibility of the pre-termination negotiations. So you don't approach these questions about improper behaviour in the way you would approach a standard section 98(4) argument about procedural unfairness. Also, the EAT noted that, yes, there maybe was a lack of transparency here, but it would be very odd for a employer perhaps to invite an employee to a protected conversation up front, as it were, because there's a real risk that the employee may not attend or may not respond positively to that suggestion. Might come back to that in just a few moments when we look at practical tips. Just finishing off with the EAT decision in Gallagher, the appeal tribunal noted that there was a number of ways that parties can get onto settlement discussions, and that a meeting about one thing can shift to a discussion about something else. And it's decided that while it was decided by the appeal tribunal that whilst it may not have been fair for the respondent to use a discussion about return to work as a pretext to raise the possibility of severance or agreeing terms, it wasn't improper to do so. The last point really to note about the decision is that the EAT also said that it wasn't a brilliant point for Mr. Gallagher that he had been told he only had 48 hours to consider the original proposal. That didn't amount to improper conduct, because although the ACAS code states that as a general rule, employees should be given at least 10 days to consider a written offer of settlement and seek legal advice, on the facts of this case, the employer wasn't yet at that stage. This was just the initial, are you interested in this offer? If you are, we can prepare terms of a settlement agreement. The 10 days which ACAS suggests you have to consider it was going to follow on from that. So what you actually have here is a good example of how protected conversations can be perhaps especially suitable in certain situations or certain types of employment disputes. This is the case where you haven't got any suggestion of an Equality Act claims. You're clearly within the scope of section 111. It's a situation where the employer can be expected to have most of the information and knowledge. So there's nothing wrong with the employer saying, we've identified the roles being redundant. It's not a situation where they're prejudging a disciplinary process or anything like that. And it's an important reminder for us that the default position is that these conversations are inadmissible and that the impropriety exclusion is not necessarily an easy hurdle to overcome. I mean, one can find, as I say, it's quite rare to get an EAT case on the scope of section 111A and the exclusions. You can find tribunal cases which include examples of improper conduct, but most involve some kind of unfair ultimatum being given to the employee and behaviour that would, at a fairly cursory sort of glance, fall under the label of clearly inappropriate behaviour like bullying or really putting undue pressure on the employee to sign a compromise. So this leads us to the question, I think, as we come to the end of our webinar, about what a employer can say or do at the meeting to avoid a finding of improper conduct that renders the entirety of the discussions disclosable. So we've got 6 brief bullet points here. The other thing you can look at is the ACAS code, which comes up with some guidance for employers too. But let's look at what we've got here. So the first point is to lay the groundwork for the matters that you intend to raise with the employee. It may not always be helpful or advisable to invite the employee to a protected conversation or a meeting under section 111A, because as we mentioned earlier, they may be not willing to come along to that. But if you have an employee who's hit by like a bolt from the blue without any real sort of pre-warning or sense of there being a problem with their employer in the preceding weeks or months, and the employer doesn't have the rationale and the evidence to support their case that there's an issue with this employee's performance or that there is a potential redundant situation, then you can see that the meeting is not going to get off to a good start. I mean, you can't control as the employer how the employee will take the news that their employment with you may be coming to an end. But if you've properly set out your rationale as to why you've come to that view, and you've documented the issue with performance, and you've maybe had the manager raise it in an informal way beforehand, then that will stand in good stead. If not for the settlement, stand the employer in good stead. If not for the settlement discussions, then for the any subsequent tribunal proceedings. So it's really about, if you do the groundwork, you perhaps reduce the chance that the matters discussed will come as a complete surprise to the employee and set the right tone. Second point, I mean, yeah, go on.
Yeah,
sorry,
yeah,
Amy.
sorry,
Yeah.
I have a note taker present. That will inevitably help. It reduces the risk of finding that there's been improper conduct or an allegation. Inevitably, if, say, for example, the question of whether the discussions are inadmissible comes up for a preliminary hearing in the event of a claim by the employee, we can see from all these cases that the factual circumstances that pertain to those discussions can be critical in determining issues such as, for example, improper behaviour. So you're always more protected if you have someone present to take notes.
And then be absolutely clear, third point there, with the employee, that these discussions you're having are meant to be without prejudice and are a protected conversation. You should do your best to explain that in a common sense way. Obviously, it depends whether you've got an employee who's got legal representation with them or not. But in most cases, you're going to have the employee there by themselves or perhaps with a work colleague. And you need to explain to them in simple terms that this is effectively an off the record discussion. That doesn't necessarily need to be done in advance. And doing so might have the effect of dissuading the employee from attending. But it can be explained at the start of the meeting or before you get to that part at which you move on to discuss a possible settlement.
Consider inviting the employee to have a work colleague or a trade union rep present. It's not a legal requirement and it will depend on the circumstances, but it's suggested by the ACAS code, paragraph 13, and say that it is good practice, and it can also help to progress settlement discussions. If the employee is being invited to discuss absence or performance issues, then in fact inviting them to bring a colleague or a representative won't seem so odd or unusual. And of course, as an absolute minimum, management will want a note taker present.
And then the fifth point, deliver the information you're giving to the employee in a neutral and fact-based fashion. What the cases make clear is that you need to be absolutely clear as the employer that these are only proposals. Nothing is predetermined. We are merely exploring whether there's a scope for us to reach an agreement between you and I on this issue. It's about being neutral. It's about being fact-focused. And you can say to the employee, you can say to the employee, look, we're allowed to do this under the law. The Act allows us to have these discussions, and that's all we're doing here, exploring whether we might be able to come up with a mutually acceptable resolution to this issue. And then the last point is that once you've concluded the meeting, it's always obviously a good idea to follow up the proposals you explored at the meeting in writing. And that's certainly a stage at which you can reiterate not only what was said with reference to your notes, but also that everything was without prejudice and covered by section 111A. So really what we're saying here is, as we come to the end of this webinar, that as employment lawyers, we are perhaps risk adverse to using this mechanism. But rhetorically, one asks, what has the employer really got to lose by using this method, which is permitted by Parliament for employers who want to resolve employment disputes? Many employees who are unhappy at work, be it due to performance issues, concerns, personality clashes, poor attendance, will prefer to agree an early departure and move on. And certainly most employers would prefer that this kind of short and swift resolution of a dispute to a long drawn out redundancy exercise or performance process. So hopefully with some of these tips that we've talked about today, if you advise employers or employees who are looking at departing from a employer, these might help you to navigate these waters. So I think we've just got a bit of time for questions. The first one which I've seen has been asked is, would matters discussed in mediation, could that be relied on in a subsequent ET claim?
No, is the short answer there. Mediation, obviously, the whole value of mediation is that it is entirely confidential, and you cannot have that taken advantage of in subsequent litigation.
Yeah, I mean, there'll be the mediation will have, if it's a non-employment tribunal mediation, there would have been without prejudice sort of rules set out beforehand. So Amy's entirely right. Obviously, none of that would be admissible. Do you want to take the next one as well? Or
I think there's one that I think is pretty pertinent in terms of what we've been discussing. If a claimant brings multiple claims, for example, ordinary unfair dismissal and discrimination, and it is determined that evidence of protected conversations is admissible for the discrimination claim, but not the ordinary unfair dismissal claim, how will this work in practice in respect of actually managing and defending the claims where evidence can be included, responded to in respect of one claim only?
So I think you're going to have, I mean, it does obviously involve difficulties, because you're going to have a situation where the tribunal is going to have to put outside its mind certain evidence which it's going to hear in relation to the discrimination complaint when considering the unfair dismissal complaint. So you're likely to have a fairly careful case management discussion at a preliminary hearing, first of all, to sort of set the parameters for the final hearing about on what aspects of the case will the evidence be admissible. But then at the actual final hearing, I think the tribunal just has to correctly direct itself which bits are relevant to which complaints. And they should be able to do that because they are used to putting out of their minds evidence which is not admissible. And
Faithorn's pretty clear about that separation, compartmentalisation that the tribunal needs to do.
The last question I think we've got time for.
Handbook, is that one?
I've got one here saying, what if the employer is off sick? Can we invite them into the? And this actually happened in Gallagher. He'd been off sick for 2 weeks, and it's when he comes back off sick that they decide to have the meeting, and that would probably be the most prudent course of action.
I think so. Yeah.
I don't know if you've got any other questions.
Which IDS handbook do you refer to? I think it's the Employment Tribunal's Practice and Procedure.
Yeah, that'll be the one.
You're going to find information on section 111A. I think that's everything, isn't it?
Yeah, I think it is. So just, I think, falls on us to say thank you very much for attending this webinar. If you do have any unanswered questions, then you can always follow them up by email to events@42br.com. You'll find that a recording of this webinar will be available on the website and our YouTube channel shortly. And obviously, as ever, we're grateful for any feedback you may have. And a final plug for the remaining sessions of our employment webinar series. Sessions 5, 6, and 7 will be running from next month. So I think that's May to July. And you'll find out in the next few weeks what those sessions are going to cover. So keep an eye open for those. And we hope you can join members of 42BR at those webinars also. So thank you very much for coming this evening.
Thank you.